Okay, folks, a little bit of technical difficulties there. My camcorder shut down sua sponte, or of its own volition, as us lawyers like to say. And so, because of that, this has de facto, in factual reality, become part 2 of Notes 3. We are still talking about agency and agency relationships. I was just finishing up the middle of the first page of the notes talking about powers of attorney, and I pretty much said everything I wanted to say on that. So now we're going to go into examining the different ways of determining if agency exists and what the scope of that agency is. Now, there are a number of different ways that the law looks at this. One of the things that the law looks at is what's called actual authority. Authority meaning that the principal has given the agent the power and the legal right to do certain things on behalf of the principal. And actual authority is where the principal has said to the agent, go out and do this, find a piece of property, buy it for me, sign a purchase and sales agreement in my name, put a deposit down, and I will be bound by that agreement. I will go through with it and finalize it. With actual authority, the agent is doing what they've been directed or ordered to do. The principal is bound by whatever contracts or agreements the agent enters into within that actual authority. Again, the best way for this to operate is to have this set out in writing and to be very clearly stated, but in the reality of the business world, that very often does not happen, and it arises by other ways and other means, sometimes by the implied action of the principal and the agent, and sometimes by the way they relate to third parties. There is implied authority. Now here we're talking about implied authority, particularly in terms of third parties looking at this situation and seeing there is an agent, there's a principal. What is the agent allowed to do? What can I rely upon? Much of this, again, could be handled if there is a written agreement and a copy of that agreement is provided to the third party, but that rarely happens except in very large transactions or in transactions such as real estate transactions or loan transactions where definitive documentation is required by law to make things valid. We get into the situation with implied authority where you are sometimes as a third party guessing what's going on. So you are trying to sell your product to a medium-sized company. You call around, you ask for different officers, and finally you're told that Fred is the manager of the purchasing division and you should deal with Fred. And you call and leave your number for Fred, you email Fred, you beep him on LinkedIn and contact him, and finally Fred calls you back one day and you discuss prices and the qualities of your products and what types of things you have, and Fred says to you, oh, I'm very interested in actually buying 1,000 units of your XYZ product. At which point you say to Fred, well, email me order request and I will email you back confirming you the price, and we'll go from there, we'll get the order ready. You, as a third party, now produce those goods. You manufacture them, you send them off to the company, and all of a sudden a vice president is emailing you saying, Fred had no authority to enter into a contract that large. We didn't approve this. We're not dealing with this. We're not paying for it. So now you're going to take, or your company's going to take a loss for these goods that have been manufactured and shipped, and for which you thought you were going to be directly paid. And in business, that happens very often, particularly when you're dealing with tangible goods, office supplies, equipment, the raw materials for products. Very often things are shipped on credit. So it's 30 days after delivery that payment is due. So things do get delivered very often before they're paid for. A little bit different from in the consumer realm, where very usually as consumers we're required to pay something up front and then it gets shipped. In the business world, that does not always happen. But even if it wasn't shipped yet, if you had manufactured all these goods and the deal was that upon finishing the manufacture, they would send you a check and you would ship the goods. And now when you inform the company that the goods have been made. They're ready to be shipped. Please send us our money. You now have somebody saying they have authority over Fred, and Fred didn't have the authority as an agent of the company to buy your goods, so therefore you're out of luck. In this situation, the law says that we need to look at the third party and try to prevent injustice to third parties. So if the company put Fred in a situation where it looked like Fred did have the power to sign this agreement to buy these things, if they let him go forward and make emails and particularly send out things on their letterhead or with their logo on the email, if when you called the company you got put through to Fred as the procurement manager, which just by his title would indicate the ability to buy things, if all those things come into play, even if Fred had no actual authority from his bosses, from his company, the third party might be able to prevail and say that the situation created by that company, by Fred's company, was such that the third party had the right to imply that Fred had authority and to proceed on that, and therefore the principal should be bound because the principal created the situation by putting Fred in a position where it looked like he had the authority. So this becomes a very critical juncture in terms of determining will the Fred's company ultimately be responsible for paying for these goods or not. So just be aware of that fact that when a third party is dealing with outsiders, how the authority appears to the third party, what a reasonable person would believe is going on here, can be just as important as the actual written agreement between the agent and their principal. The law basically takes a position that the third parties should not have to be responsible to dig in and to find out every bit of minutia about what's going on between a purported agent and a purported principal, and that if certain things exist, certain facts on the ground exist, then the law is going to protect the third parties by creating that agency by implication in law, even if the parties had not agreed to that. The principal agent, supposed principal agent, had not agreed to that and had not put that in writing or in any other type of memorandum or whatever. Okay. Similar to this, but a little bit different, is something called apparent authority. Apparent authority is a situation where, again, a third party would normally believe that the person I'm dealing with has the power to do this type of thing, and therefore I am able to rely on what they're saying and rely on the fact that my contract will be valid and will be honored by the principal. Hard at times to differentiate this from implied, and many times implied and apparent kind of overlap with each other. Apparent authority is in a situation where there may be absolutely no authority at all. You run a small consignment shop, a little antique shop. You have one of your friends comes in and you say, gee, I'm glad you're here. I need to run to the bank to make some deposits. Can you just stand here? Don't do anything. If any clients come in, any prospective buyers come in, don't make any deals. Just tell them they have to wait 20 minutes for me to get back. While you're gone, a customer comes into the store. They see a piece of jewelry that they particularly like. They ask your friend how much it is. Your friend goes looking and mistakenly sees a $5 tag that he thinks was attached to this piece of jewelry, when actually it's a $500 piece of jewelry. And thinking he's doing a good thing, your friend happily sells the jewelry to the customer for $5. In that type of situation, your friend had actually no authority whatsoever from you to do anything. As a matter of fact, he had explicit instructions not to do anything. However, by placing him in a shop where secondhand goods are sold, where prices can vary greatly and go up and down, and many times people don't know the true value of items, I think a court would hold that in this situation, the customer had every right to believe that a $5 sale of this ring worth jewelry worth $500 was valid, and I think a court would say that by leaving your friend behind the counter inside the shop, you place them in the apparent authority to be able to make that deal. And therefore, when you try to sue to get the ring back for lack of proper consideration or failure of value or mistake, I think there's a very good chance that a court would say, no, you created the apparent authority, you made it look like you were a principal, we're not going to penalize the third party for that. You, Mr. Merchant, are the one who will lose in this situation. Okay, so be aware of how that works, and that is a very important concept. We talked a little bit in the last section about estoppel, and again, estoppel is the idea that if you create a situation where you make it look like someone's your agent, in particular, if you know that this person is going out and holding themselves out to be your agent to third parties, and you do nothing to stop them, even though that person was never really or truly your agent, the law will apply the principle of estoppel and will prevent you from claiming that there was no agency relationship here, and any injury to a third party will be held accountable to you as a purported principal. All right, again, ratification comes into play here. Agent goes out and does something beyond the scope of their authority. Somebody who has no authority does something that the principal ultimately likes and says, gee, this actually would be a good deal, I want to accept it. The principal can, after the fact, ratify what the agent has done. Once the principal does that, any contracts or agreements that the agent made will become valid and binding on the principal, and they will not be the contracts of the agent. Now, that's something I haven't spoken about here, and I think we'll talk about it a little bit more as we go through this chapter, but one of the things going on here is that if an agent acts within the scope of their agency and makes a contract, it makes an agreement, the agent is not bound on that agreement at all, because in effect the agreement is being made between the third party and the principal, and the agent is just acting as a conduit. They're acting as a go-between. So in situations where an agent acts within the scope of their authority, does what their principal has told them to do, and then all of a sudden the principal changed their mind or doesn't like the deal or somehow gets sued in the deal, the agent is not involved. It's between the third party and the principal. The agent only becomes involved in situations where the agent was doing something that the principal had forbid them to do, something that was beyond the scope of their authority, and then in those situations, sometimes the agent can be found liable for the contracts and the agreements. Ratification, in order for it to be valid, has several requirements. Number one, there has to be a disclosure that I'm acting on so-and-so as their agent. They are the principal. So it cannot be complete. The agent doesn't tell the third party that they're an agent, but then goes to the principal and says, oh, I just made this deal. The principal has to be informed of all material facts of the situation. So when the agent finally tells the principal, oh, I know you didn't want me to, but I went out and did this, every important piece of information has to be disclosed to the principal, or the ratification is not valid and can be reneged upon. The principal must affirm the entire agreement. So it can't be picking and choosing, well, I like this clause of the contract, but I really wouldn't have agreed to that, so I'll agree partially. It's kind of a give all or take all. The third party has now entered into what they think is a final ratified agreement, and the principal therefore is stuck with either accepting the whole thing or rejecting the whole thing. The principal must have legal capacity at the time of the agent's actions. Now, this is something we hadn't talked about yet, and I think when we get into liability, it may come up again. But with powers of attorney, one of the things that happened under the traditional law was that it was held that an agent, because they were working for the principal, could only have the same power as the principal had at the moment the agreement was entered into. This became a very sticky problem in situations where a principal became ill, became incompetent, and the agent wasn't aware of that. And again, think of the old days when communications were very long and very slow. You send somebody out to the West Coast to act as your agent. It takes 4 weeks for the mail to get back and forth. You become ill, you become incompetent. It takes 2 months for the agent to learn of that. The agent is making contracts on your behalf during that time. Under the old interpretation of the law, any contract made after the moment you were declared incompetent becomes null and void and doesn't exist. Now, under recent legislation, by recent I mean like 30 years, the states have changed that. So at least in a written agency agreement and a written power of attorney, you can now make a declaration that this power of attorney will continue in effect even if I become incompetent. Death, however, ends all arrangements. So that if the principal dies, then anything that occurred after the death of the principal is normally deemed to not have validity. And often, even if the agent didn't know of the death of the principal, it is still said that once the principal has died, any authority they gave to the agent is gone. Now, with corporations don't necessarily die. So if you're acting as the agent of a corporation, that's less of a big deal than if you're the agent of a private, living, flesh and blood individual. The ratification has to occur before the third party withdraws, which means that if the third party discovers that the agent had no real agency or was acting beyond the scope of their authority, the third party has a right to call this what it is and to say, no, there was no deal there. The person had no authority to enter the deals, and since there is no deal, I'm canceling the whole thing. It never existed. I'm ripping up the documents. We're done. So if the third party makes an attempt to dissolve the situation, to terminate the situation before the principal ratifies, that dissolution and termination is valid and takes precedence over the ratification. And again, the ratification must involve all the same formalities that are required of the actual transaction. So if it had to do with the buying and selling of land, it would have to be in writing. If it had to do with land title documents, it would have to be in writing and notarized. The ratification must have the same formality as the requirement for the actual deal to go through. Now, moving on from there, we begin talking a little bit about who's liable for these contracts. As I said a minute ago, the whole point of an agency is that the agent will make these agreements, but they become the agreements of the principal. So the principal is liable for the agreement, and the principal also gets all the benefits from the agreement if the agency has been conducted properly. If the principal is fully disclosed, so the third party knows that this person in front of me is only an agent, or this person I'm dealing with by email or on the phone is only an agent, then there is no question. The agent is not responsible for the contract. It is between the principal and the third party. If the agency is only partially disclosed, and this happens in situations very often where a principal does not want to have the party they're dealing with know who they are. This particularly has to do in business with people or corporations that are very wealthy and they're trying to procure goods and services. They may not want the third party to immediately know who they are, because if they look at it and say, well, they have a lot of money, they are very well capitalized, we're going to raise our prices. Particularly in land transactions, this happens. So very often, you may send an agent out to somebody trying to sell a piece of property and tell the agent, negotiate a deal, but don't let them know who I am. Now, if the agent reveals that they are an agent, they don't necessarily have to name the principal, as long as they've made it clear that they are acting on behalf of a principal. As long as they stay within the scope of their authority towards that principal, they are not liable on the contract. If they go beyond the scope of their authority for that principal, they could be held liable, as the third party has no way of finding out who the principal is to test the scope of the agent's authority. This may sound like a bizarre situation, but it does come up. Next to my cabin in New Hampshire, there is a 34-acre piece of land that has been for sale on and off for 7 years, since the last owner of it died, and his family, his heirs at law, don't seem to know what they want to do with it. At first they were asking an outrageous price for it. They have moderated the price at times. I would be interested in acquiring that land, because it would prevent somebody from building right next door to where I am, and it's a fairly decent piece of property. It would be a nice addition to the little piece of property that my wife and I own. However, When I hired my real estate agent to go inquire about this, I gave her specific instructions that she was not to let the people know that it was the next door neighbor who was interested in buying, because quite afraid that if they knew it was me and that I wanted this land to add to the property I already owned, that the price would go up, or that they would stay firm in their price and not negotiate, knowing that I really have nowhere else to go or nowhere else to try and get a hold of this land, and that they would necessarily hold all the power in the situation. So in recent times, the deal has nothing has ever come of it. They've never agreed to anything my real estate agent has proposed. But even in my own life situation, I had set up an agent, and I had asked them to act as a partially disclosed agent, to go in and tell these people, yes, I have a potential buyer, but I'm not able to tell you who that is until we've actually signed an agreement. If a third party does not know that this is an agency at all, that is totally undisclosed, that there's a principal, then the agent becomes liable, because the third party is led to believe that they're actually entering into this deal with the agent. They believe the agent is in fact the principal. And in those situations, the law is clear. The third party should not suffer for this scenario that the principal and agent have created. So the agent would be liable even after the fact if the third party found out there was a principal, or what would most likely happen, they would try and sue the agent if something happened, if the deal broke down, and now the agent's claiming, oh no, there was really a principal. Well, the third party could actually at that point go and sue that principal, and they could sue the agent. The agent would not be let off in that case. All right. Authorized acts. Certainly, if a disclosed or partially disclosed agent is acting within their authority, then they have created a binding contract. That contract becomes the liability of, and all the benefits from flow to the principal. If undisclosed, as we said, the third party can sue the agent. They can also sue the principal. All right. There are times when an undisclosed agent might actually enter into a contract in such a way that the principal can't be sued. So if the agent enters into an undisclosed situation, enters into a contract, and they're beyond the scope of their authority, and no hint of a principal agency relationship was ever given to the third party, then there are times when the principal could disavow the whole situation, and now any lawsuit, any litigation would be between the third party and the agent. And that idea is that the third party in that situation thought they were dealing actively with the agent and never knew there was a principal. And if the agent was acting outside the authority of their supposed principal, why should the principal be having to answer for something that the third party had no reason to believe involved anybody but the agent as the primary party? All right. Unauthorized acts, certainly criminal acts, intentional torts. The principal in most situations is not responsible for those types of things. However, that has changed a little bit in recent times, and we'll talk about that a little bit as we move into the next section. I'm now moving into the section 3 of note 3, which deals with liability for torts and crimes. An agent is always responsible for their own crimes and their own torts. So when an agent goes out and commits a crime, when an agent injures somebody or causes harm to property, the agent is always first responsible because they did the action. However, the question becomes, does respondeat superior, does vicarious liability exist such that the principal will also be held responsible?